She has. Statute Law Miscellaneous Provisions Bill in the name of Ms Gabrielle Upton.
I call the Attorney-General.
Madam Assistant Speaker, I move that a bill be introduced for an act to repeal certain acts and instruments and to amend certain other acts and instruments in various respects and for the purpose of effecting statute law revision and to make certain savings.
The question is that the bill be now read a second time. Be introduced. Thank you. All those in favour say aye. To the contrary, no. The ayes have it. The ayes have it. The Attorney-General.
Madam Assistant Speaker, I bring up the bill and I move that it be read a second time.
I don't need to put the question there, do I? She just talks, doesn't she? Yeah, that's the one I was confused on. Yeah. That's where I got them back to front. Yeah, Attorney. Yeah.
Madam Assistant Speaker, the Statute Law Miscellaneous Provisions Bill 2015 continues the Statute Law Revision Program, which has been in place now for more than 30 years. Bills of this kind have featured in most sessions of Parliament since 1984 and are an effective way of making minor policy changes, repealing redundant legislation and correcting drafting errors. Schedule 1 to the bill contains policy changes of a minor and non-controversial nature that are too inconsequential to warrant the introduction of a separate amending bill. It contains amendments to 26 acts and related amendments to 3 regulations. I'll describe some of the amendments to give the honourable members in this House an indication of the kind of amendments that are included in this schedule. Schedule 1 makes amendments to the Aboriginal Land Rights Act 1983 that change the nature of the resolution required to be passed by voting members of Aboriginal land councils for certain decisions of those land councils. First, those amendments will ensure that a local Aboriginal land council's community land and business plan can only be adopted by a special resolution of at least 80% of the voting members of the land council present at a land council meeting, rather than by an ordinary resolution. A local Aboriginal Land Council's community land and business plan includes the Land Council's strategies and objectives for land and business dealings. This amendment is consistent with the requirement under the Act for land dealings by a local Aboriginal Land Council to be approved by a special resolution. Secondly, the amendments to the Aboriginal Land Rights Act 1983 will ensure that the passing of an ordinary resolution by voting members of the New South Wales Aboriginal Land Council is sufficient to approve the transfer or disposal of an asset or the termination of certain arrangements by that land council instead of a special resolution being required, as is currently the case. This amendment is consistent with the requirements for other decisions of the New South Wales Aboriginal Land Council, which need only be approved by the passing of an ordinary resolution. Madam Assistant Speaker, the amendments to the Conveyances Licensing Act 2003 will remove an unnecessary duplication in the role of the Commissioner for Fair Trading and ASIC. In particular, they will remove the responsibility for approving business names of licensed conveyances from the Commissioner for Fair Trading and a related offence. The Commonwealth Business Names Registration Act 2011 deals comprehensively with both the registration of business names by ASIC and related offences. Schedule 1 contains an amendment that directly incorporates into the Gambling 2-Up Act 1998 a provision of the Gambling 2-Up Regulation 2010, allowing 2-Up to be played on 15 August, which is Victory Day in the Pacific Day, and afternoon on the 11th of November, which of course is Remembrance Day. The regulations have allowed 2-Up to be played on these days for a successful trial of almost 10 years. Schedule 1 amends several acts in the portfolio of the Minister for Health, including the Public Health Act 2010. The amendments to that Act will enable the Secretary of the Ministry of Health to provide personal information, whether or not it is also health information, to a health records linkage organisation, such as the Centre for Health Records Linkage, so that the organisation can provide unique identifier numbers for public health or disease registers. The unique identifier numbers are used on the registers in place of personal identifying particulars, such as names and addresses. Currently, only personal information that is not health information can be provided to a health records linkage organisation, And therefore, public health and disease registers established under the Act, apart from the PAP test register, cannot contain the information collected in providing a health service. The Ministry of Health has advised that the Privacy Commissioner has no objection to the proposed amendments to the Public Health Act 2010. Schedule 1 also amends the Passenger Transport Act 2014 to ensure that police officers are able to issue penalty notices for prescribed offences under the Act without having to be specifically authorised by Transport for New South Wales or Roads and Maritime Services. This amendment corrects a drafting oversight and recreates the existing situation that applies to the issue of penalty notices by police officers under the Passenger Transport Act 1990, which the Passenger Transport Act 2014 will replace. The last Schedule 1 matter I will mention is an amendment to the Veterinary Practice Act 2003. The amendment will reduce from 5 academic years to 4 academic years the minimum length of the course in veterinary science that a person must complete to be eligible for full registration as a veterinary practitioner. This reflects changes made to the courses offered by the University of Sydney and the University of Melbourne, which have changed from a 5-year undergraduate degree to a 4-year graduate degree entitled Doctor of Veterinary Medicine. This proposed amendment has been requested by the Veterinary Practitioners Board of New South Wales. Schedule 2 deals with matters of pure statute law revision, including minor technical changes to legislation that Parliamentary Council considers are appropriate for inclusion in this bill. Examples of amendments in Schedule 2 are corrections of cross-references, typographical errors in terminology, and amendments arising out of the enactment of other legislation. Madam Assistant Speaker, Schedule 3 contains amendments that update terminology and references relating to public service agencies, heads of agencies, public service employees as a consequence of the Government Sector Employee Act 2013. The schedule also includes other miscellaneous amendments that are consequential in nature. Schedule 4 makes amendments that are necessary as a result of an amendment set out in Schedule 1. Schedule 5 and 6 continues the program of repealing acts and instruments that are redundant or of no practical utility and consolidating provisions that may have ongoing operations into relevant acts. Madam Assistant Speaker, Schedule 5 enables the repeal of Schedule 6 of regulations that were made as a consequence of the dissolution of the Australian Inland Energy Water Infrastructure in 2005. The amendments transfer savings and transitional provisions of possible ongoing effect into the Electricity Supply Act 1995 and the Energy Services Corporation Act 1995, which are the acts under which the regulations are made. Schedule 6 repeals 7 acts and 3 regulations in their entirety, including the Gambling 2-Up Regulation 2010, which is made redundant by amendments to the Gambling 2-Up Act I mentioned earlier. The schedule also repeals a number of provisions from other acts and regulations. Madam Assistant Speaker, Schedule 7 contains general savings, transitional and other provisions. These include provisions dealing with the effects of amendments on amending provisions, savings clauses for the repeal of acts and provisions. The various amendments are explained in detail in the explanatory notes set out beneath the amendments to each Act and statutory instruments concerned or at the beginning of the schedule concerned itself. Madam Assistant Speaker, I'm sure that honourable members of this House will appreciate the straightforward and non-controversial nature of the provisions contained in the bill before the House. However, if any amendment requires clarification, it should be brought to my attention and the attention of the responsible Portfolio Minister. If necessary, I will of course arrange for briefings and additional information on the matters raised to be given. Madam Assistant Speaker, with that, I commend the bill to the House.
The question is, if this bill be now read a second time, I call the member for Port Stephens.
I move that this debate be adjourned.
The question is, if this debate be now adjourned, all those in favour say aye. To the contrary, no. The ayes have it. The ayes have it. Attorney General.
Just move that it be adjourned. adjourn to a future date.
Madam Assistant Speaker, I request that the debate be returned as an order of the day at a future day.
I fix the resumption of this debate as an order of the day for a future day.